Good morning, everyone. Today we'll be discussing a significant legal case, Sandra Jones versus Winnie Tsige. This case decided in 2011 by the Ontario Superior Court of Justice addresses critical issues surrounding privacy, professional ethics, and the legal framework for invention of privacy in Ontario. Our presentation will cover the case background, the facts, the legal questions it raised, and the court's conclusion. Let's begin by understanding who we are, like which is my team. So let's move to the Privacy Patrol. Like my team name is Privacy Patrol. Before we dive into the case, let me introduce the whole team. My name is Rahul, and with me there is Lavish, Goyal, and Komalpreet Singh as well. Our goal is to ensure that by the end of this presentation, you will have a we will have a thorough understanding of the complexities and the significance of this case. This case involves two employees of the Bank of Montreal BMO, Sandra Jones and Winnie Tsige. Sandra Jones, a project manager, discovered that her personal banking information had been accessed 174 times by Winnie Tsige, a licensed financial planner at BMO. This unauthorized access spanned nearly 3 years. As a result of her action, Ms. Tsigi was suspended and lost her annual salary as well. The central legal issue in this case was whether Ontario recognized a common law tort for invention of privacy. The court ultimately concluded that no such standalone tort exists under common law, but other some remedies might apply. Legal focus on there is a common law of invention of privacy. The case highlights the tension between evolving social norms around privacy and the established legal frameworks. So let's move to the next slide, which is like in this we'll talk about some interesting facts. So let's dive into the facts of the case. Sandra Jones, who is the plaintiff, worked as a project manager at BMO and conducted all her personal banking with the same institution. Winnie Tsigi, the defendant, had been employed by BMO from last around 20 years from August 2006 to July 2009. Ms. Tsigi accessed Ms. Jones' banking information 174 times without authorization, like without any kind of needs. The access information included account balances, transaction records, and other personal details as well. What is the breach? Like the breach was discovered by BMO, which led to Mr. Segi's suspension and the loss of her annual bonus as well. When confronted, Mr. Sigi admitted to accessing the information to verify her common law partner, who was also Miss Jones' ex-husband, was paying child support. She basically accessed his account to just to look like he's just supporting his child or not. The legal focus of the case was whether this act constituted a common law tort of invasion of privacy. The court concluded that there was no standalone of invasion of privacy in Ontario, suggesting that statutory remedies such as the Personal Information Protection and Electronic Documents Act were more appropriate. So the next slide will be discussed by Lavish.
Hello everyone. Today we'll talk about relation between the Sandra Jones and Tsige. Sandra Jones and Winnie Tsige had no prior acquaintance before this incident. The unauthorized access to Miss Jones' banking information by Miss Tsige was solely due to Miss Tsge's relationship with Miss Jones' former husband. This case is an example of how personal relationships can sometimes lead to significant breaches of privacy and professional ethics, especially in environments where sensitive information is accessible. Mr. Ski's actions were driven by personal motives rather than any professional necessity, highlighting a severe lapse in judgment and ethics. Next slide. We will discuss about some issues. This case raises several important issues that need to be considered. Did Ms. Chesky repeated Unauthorized access to Ms. Jones' information constitute a violation of privacy laws. Does Ontario law recognize a legal claim for invasion of privacy? If not, should it? Were the disciplinary actions taken by BMO against Ms. Tsige appropriate and sufficient? What is the role of the judiciary in creating new privacy rights and obligations in response to evolving sociality norms? Did Ms. Jones suffer specific harm or loss that justifies compensation beyond the breach of privacy itself? To what extent did Mr. Ski's actions violate professional and ethical standards in the financial services industry? These questions not only relate to the specifics of this case but also touch upon broader issues regarding privacy rights, the responsibility of financial institutions, and the evolving nature of common law in response to new sociality challenges. Let's move to next slide. Uh, Issues clarification. Ms. Tsige actions undoubtedly violated privacy laws by accessing Ms. Jones' information without any legitimate reason. The court confirmed that Ontario does not recognize a common law tort for invasion of privacy. The disciplinary actions taken by BMO against Ms. Tsige, which included suspension and the loss of her annual bonus, were deemed appropriate given by the seriousness of her misconduct. The court opined that creating new privacy rights should be left to lawmakers who can enact comprehensive legislation addressing such issues. Ms. Jones did not suffer specific tangible harm beyond the invasion of privacy, which is an important consideration in determining damages. Mr. Ski's actions significantly violated professional and ethical standards expected in the financial services industry, where the protection of client information is paramount. By examining these issues, we can gain a deeper understanding of the complexities involved in this case and the challenges of balancing privacy rights with existing legal frameworks. Now, my friend Komalpreet will continue with the next slide.
Hello everyone, my name is Komalpreet Singh. Here I am discuss about holding. The court held that there is no common law for innovation of privacy in Ontario. This means that under common law, individual can sue for innovation of privacy as a standard claim. Instead, individual like Ms. Jones must rely on remedies such as those provided under the Personal Information Protection and Electronic Document Act. The court found that these existing privacy laws are adequate to address privacy violence and provide appropriate remedies. This decision underscores the importance of statutory framework in protection privacy and sets a precedent for how similar case may be handled in the future. Now I have to move next slide, which is relations. The relations behind the court decision is grounded in legal precedents and the decision of existing privacy laws. The court referenced the Lee case, which established that there is no standard common law like to privacy. This guides the court consultation that creation a new common law for innovation of privacy was unnecessary. Furthermore, privacy law like PIPEDA are carefully designed to address specific industries concern such as banking. These laws are made to protect personal information within particular contexts and provide mechanical for addressing branches. The court believed that these existing laws are more appropriate and balance than creating new judge-made law which could leave the incontest and uncertain in the legal landscape. This decision highlights the importance of legislative action in developing privacy protection. Now, my friend Rahul move further.
Okay, thank you, Komalpreet Singh. So let's talk about what is the final decision of the court, like what judge make the final decision. The final decision of the court emphasized that there is no common law tort of invasion of privacy in Ontario. Instead, the court pointed out the existing statutory schemes like PIPEDA, which are designed to address privacy issues comprehensively. This design reflects a preference of legislative solution over judicial innovation in the realm of privacy rights. By relying on established statutory frameworks, the court aimed to provide clarity and consistency in how privacy violations are addressed. This approach ensures that privacy protection are aligned with the specific needs and contexts of different industries, providing a robust and reliable means of addressing breaches. So let's move to the final slide, which is interesting facts. These are not basically the interesting facts, but some are the things which we have to notice. So Sandra Jones, who is the plaintiff, is a project manager at BMO and the victim of the unauthorized access. Despite the breach of her privacy, she continued banking with BMO. This is the interesting fact. Like after this kind of things, she continued banking with BMO and decided to initiate legal action to address the violation of her rights. Winnie Tsige, the defendant, had been employed by BMO for 20 years. During this time, she accessed banking records without authorization numerous occasions. Following the discovery of her actions, BMO disciplined her by suspending her and withholding her annual bonus as well. Ms. Tsige later apologized for her actions and pledged into not to repeat them, acknowledging the gravity of her misconducts. These facts provide a personal dimension to the case, illustrating the human elements behind the legal issues and the impact of professional misconduct on individuals and their relationships. So let's talk about the conclusion, like what is the conclusion in this. Thank you for attention. This concludes our presentation on the Sandra Jones versus Winnie Tsigi case. We are Privacy Patrol from Alpha College, and this presentation was part of our administrative law course. Through this course, we have explored important questions about privacy, professional ethics, and the role of law in addressing emerging societal issues. We hope you found the case analyzed, insightful, and informative. If you have any question or would like to talk to us, you can just uh, be helpful to send us a mail. We would be happy to engage in a discussion. Thank you.